Ladies and gentlemen, let's get straight into this. Now, we have the case of Mr. Kyle Rittenhouse. Now, if you guys don't remember, Kyle, definitely a proper name for him. But anyway, Kyle was accused for shooting three men. So he was arrested. It was during the protest and the parade and all that stuff. They were burning down car lots, and he wanted to have a militia to protect the car lot across the street. Long story short, he had to use his weapon, ends up in court. Now let's see how the prosecution basically starts the argument off, and the judge, guys, you're going to see how he behaves throughout the court. And this is just as much a Judge Bruce Schroeder case as it is a Kyle Rittenhouse case. But let's get straight into it.
You were talking about going on the internet and downloading some videos, and we're going to get back to that in a second. But I want to go back to the evening of early morning hours into the next day of August 25th, August 26th of 2020. Did there come a time in which you learned the identity of the person who had shot people that night?
Yes.
How did that come to be?
There was information on social media, and also we received information that the person had turned themselves in at the Antioch Police Department.
Now, I just want to point this out first and foremost. I'm not going to give a strong opinion on this case, but what I will say is that a lot of people were jumping to conclusions about this kid when it first happened. The first thing people were saying is that, oh, he shot the black people during the protests. Rah, he should go to jail forever. Like, social media is a real dangerous place if you just look at video clips, or even worse, in this case, we were looking at comments, and we were looking at him running around with the gun after the fact. So nobody really knew what was happening. Behind the scene, kid was turning himself in already. So, you know what I mean? Be careful about what you see online and what you quickly start tweeting away about.
Prior to the defendant turning himself in at the Antioch Police Department, did you have information identifying him as the individual who shot and killed two people that night?
There were pictures circulating on social media.
Were you able to see or figure out the identity of the person in those pictures?
Early on in the investigation, I recall seeing a picture, but I do not recall knowing the identity of the person immediately.
Did there, after the defendant turned himself in to the Antioch Police Department, did you go down there in person?
Yes.
And did you have face-to-face contact with the defendant?
Yes.
Did the defendant indicate to you that he had suffered some injuries that night?
Yes.
Did you take photographs and document those injuries?
Yes.
Can you tell the jury about those injuries?
He had an approximately half-inch scratch above his left eyebrow. He had...
And keep in mind, his whole defense right now is self-defense, right? You know, people were coming at him. You know, they were about to attack him, so he had to shoot them. But why? My whole question about this trial was, why are you out there with a gun in the first place? If you have a gun, that means you're going to use it if need be. It's not a prop. You know what I mean? It's not a prop to scare people away, because some people will try you, clearly. And, you know, a riot, people don't behave the same. It's been studied. People do not behave the same. It becomes this hive mind mentality of, so if one person starts rushing, everybody might start rushing. Weird shit starts to happen.
A small cut on the inside of his lower lip, slightly offset to the right. There is a approximately 2-inch scratch below his left collarbone. There was some redness to the right side of his belly button, just above his waistline. There was an approximate 2-inch scratch on his left forearm. There was some redness on his right forearm. There was some redness on the tip of his right thumb. And on his back, there was a scratch somewhere on his left side, about the where the left shoulder blade would be, in that approximate area. And also there were 2 bumps on the back of his head that was approximately here. So
Oh, they were fucking him up. They were fucking him up. I mean, that's all I could say. Unless he just kept falling and tripping over his gun. But we're going to see a little bit of body cam footage and stuff like that. But social media really amped this up as like a hate crime. Like when I first saw this thing, it was crazy. They're like, oh, he's a white supremacist. Oh, this kid, look into his social media. We're going to find things about him. And it was crazy. It was a wild time. Even I was kind of like, yeah, that's crazy. He just started shooting into the crowd. Come to find out, he was wrong for taking the gun, in my opinion, but he was right to defend himself. Like I wouldn't stand there and die either. You guys
above the left ear, both of those injuries on his head, I could not get to turn up in the photograph because Mr. Rittenhouse has very thick hair. But with the gloved hand, I was able to feel it. And both of these bumps I would approximate to be the size of a penny. And the skin was slightly raised, and I was able to feel that with my hands.
So he got hit in the back.
Was that the extent of the injuries that the defendant reported to you?
Yes.
At the end of the day, it's not the most crazy thing. You'll get worse injuries like that fighting a friend, you know what I mean? You'll get worse injuries like sparring with somebody at the end of the day. So, but if you feel like you're gonna die, in different circumstances, you may have, the legal ability to do so.
Now, I know you talked about getting some videos off the internet. Was there a time in which you also collected some physical evidence from the scene of the shootings?
Yes, at 63rd Street and Sheridan Road, yes.
And can you tell us about that?
That was on August 29th. We had a citizen by the name of James Powarczyk. I might have gotten his last name off.
Powarczyk. God dang, where is he from?
Last name a little bit off, but I think there were two W's in there. I think it was Powarczyk. We got a report from that the citizen came to check out the area of where this had happened, and he located two shell casings underneath a silver Chevy Cruze in the car source parking lot.
Karen, that last name is Piwowarczyk. After receiving this report, did you go to that scene to check out these shell casings?
Yes.
Did you recover those shell casings?
Yes.
And what were they specifically?
They were two Aguila 223 REM shell casings, and the location of where they were located, the silver Chevy Cruze was right in the area of what I had seen on the videos of where the shooting of Joseph Rosenbaum had taken place.
And I think Rosenbaum, so he didn't kill 3 men. I think he killed 2 men, wounded 1. I think Rosenbaum was one of the ones that survived.
Thank you. Now, you mentioned earlier that as part of your investigation, you searched social media, the internet, etc., to gather videos of this particular night. Is that correct?
Yes.
Okay. I'd like to go through some of those videos now in your testimony. Let me turn the TVs on. The first video that I'm going to show is on our... Oh,
I don't know why the prosecutor looks like he's a dude out of a movie. He just seems like the douchebag, witty lawyer. I don't know.
This is a video which is on our list as exhibit number 18. And this is a video from a news source called The Rundown Live. So if we could begin this, begin playing this at the very start, please.
Kristan T. here at the Rundown Live, and I'm here with a bunch of militia. They're protecting a local car shop across the street. I saw yesterday there's video of it on YouTube of this one burn. And we have that fire and people are hitting it with bats and a whole bunch of other things.
I have an objection to this audio being played and the
Kyle's right there.
editorialization. I don't have a problem with the video being played.
Now, now keep in mind, Kyle has an excellent lawyer as well. And we're going to see how the judge quickly favors one lawyer over the other. Very biased, you know, you're not supposed to be biased, but it's very visible.
I think we've agreed to the authenticity of it. I think that the individual who recorded this is available to be subpoenaed if necessary.
Well,
I don't think it's.
There's a rule of confrontation.
May we approach, Your Honor? I don't want to continue this to the jury.
Well, start there. Start from that position and we'll see. It's a confrontation issue.
Number one, the judge won't let them approach. Okay.
May we approach, Your Honor? I'm sorry.
Keep in mind, the jury, this is in front of the jury. So they're trying to approach so that it looks more professional on both of their ends, in my opinion.
It's
No, because it's be something that has to be a record, and I'll have to send the jury.
It's
on
not, I don't believe it's a confrontation issue, Your Honor, because we're going to be here, we've already heard audio from other witnesses, and we're going to hear more.
There was not an objection. I can tell you, if there's descriptive material, then he's entitled to confront the speaker.
There's not descriptive material of the defendant, Your Honor. This is not a confrontation issue.
You've heard it before?
Yeah, I've seen it in its editorialization.
He's already made statements, assertions of fact.
He just made one.
He did.
So if he makes assertions of fact, they can't use it?
We can play it without the audio. There will be times in which we will have audio of interactions with the defendant, where he makes statements.
Defendant's statements are admissible.
All right, I'll do my best to alert you when those occur. So let's play without sound for now.
When I studied evidence last century,
when I studied evidence last century, I thought we were playing a video. Like me and the jury, I would be like, scratch. Anyway, let's continue.
the evidence textbook, which was probably.
No, let me go back here and see what books I got for show and tell.
Probably about this thick.
Okay.
About a quarter of it was dealt with the hearsay rule. You hear the word hearsay all the time, and the section on the hearsay rule began. There is nothing murkier in the law of evidence than the hearsay rule, and I can tell you from 50 years of experience that that is accurate. It is a rule that has many, many exclusions, and it has many, many exceptions.
This man knows that this trial is televised and it's going to be real big. And now he's giving us history lessons. The man, the lawyer, the prosecutor is about to admit a video. They just had a confrontation about it, right? I don't even think the defending lawyer, the defense, he didn't call hearsay. All of a sudden, he's giving us a history lesson right before he's about to admit this very, possibly important piece of evidence. So I don't know what's up with this guy.
So some things that may seem to the untrained ear to be hearsay are not, and some things that don't seem like it are. Basically, the rule is that a statement of a non-testifying person cannot be offered to prove the truth of the matter which is asserted in the statement.
So he's saying because the person in the video is talking, basically, it's hearsay, if I'm understanding it correctly. And just because the defendant isn't speaking at the moment, you can't have the audio because it would be hearsay. But they're saying they could subpoena the person to come in and testify to that statement, but apparently he doesn't want to hear that.
The rule, this is something we actually referred to on the first day when I talked about what's introduced in evidence has to be under oath. It has to be subject to cross-examination. And that's not true of statements that are made by somebody who's not here while testifying as a witness. He's not here on the stand, he's not under oath, and he's not subject to cross-examination. So this person who's describing this is occurring on a discussion that you or I might have if it didn't require the strict rules that we have in the courts. Perfectly, ordinary conversation.
But they could subpoena him to testify about the statement. No, big brain movements. Oh my God.
It looks like he's in the car source parking lot. I'd say about there. The viewpoint of the video.
I just want to point out that I cut the judge, right, to the detective, but I just left a little ending of it. He took so long that the editors of the original video cut him. Bruh. Yeah, you get where I'm going here. The judge, man, I don't know. I don't know.
Video is pointing north towards St. James Church.
And we've already heard some testimony about the fact that St. James Church on our map looks like it's got a structure there, but in the video it's changed. Are you familiar with that?
Yeah, St. James Church at this time, and a little bit prior to these incidents, was going through a demolition.
Okay, thank you. Please.
Well, the former school building,
Yeah, the school building.
not the church.
Correct.
Okay, wait. I'm tripping. The judge can interject. Never mind. I just don't like this guy. I don't like him. Bruce, whatever his last name is, bro, you guys let me know. Am I tripping on the judge, or does he just seem, I don't even want to say he seems biased, but I just feel like he wants attention. He just wants attention.
Let's continue the video, please.
Like, yeah, let's continue. Make sure you guys get your beverages of choice. Still on that water.
We're live on the Rundown Live. And as you can see,
There he is with his gun. Now this, if I was the police officer passing through and I saw this shit, I'd be like, boy, if you don't get your ass inside, you don't protect property, you protect lives. They burnt down the other lot. They could burn this lot down. You know how much insurance this company has on all these cars? They're praying to get burnt down. What are you talking about?
do you have a good angle? Yeah, very cool. And you guys local or no? Yeah. Yeah. Okay. Cool.
I'm Kyle, by the way.
No, we'll do this.
Coronavirus.
Oh, dude, I'm not afraid of no coronavirus. In fact, my shirt underneath, it says, I survived the coronavirus. There you go. Yeah.
Everybody like the video and comment if you caught coronavirus. I caught coronavirus toward the end of it, and I just used it to get out of work. I didn't want to go to work. I felt absolutely fine. I think I felt sick for a day, and then I couldn't really taste things properly or fully. And I just used all my sick hours. I was like, oh yeah, I have coronavirus. And I would test like every time, and I would show them the test, and they would be like, don't come to work. Don't come. I milked that thing for so long. I feel bad for it, but yeah, the coronavirus did not scare me. I thought the world would end for a minute, but after a few months, I was like, oh, okay. Okay.
It's very possible. Was that?
I'd be safe. It's dangerous.
Oh, bro. Believe it or not, I've been doing this for about 12 years, so 41.
Shit, how old are you? I swear, kids, they don't even care. I've been doing this for about 12 years, but oh shit, how old are you? Like, damn, son, relax. I know you got your M16 or whatever there, but your AR-15, but like, chill. Feeling all confident.
And, if you guys see me get hit with something, I'm knocked out, that's when I need help.
Yep.
Or if it looks like somebody's going to beat me at the club, then I need help. Other than that, I can...
We'll be there to help.
Non-aggression principle. I don't want anyone hurt. They have medics too, and their medics are pretty helpful, even though they might be on the other side, if that makes sense. But they'll help me, okay?
We got medics too.
Okay, cool.
Now, first things first, I just want to point out he's not like, yeah, I wish they would try us, bro. Yeah, I'm gonna just pop one of them. I'm gonna just shoot one of them. he's not talking like aggressive. He's not anxious to shoot anybody. He just seems concerned. Maybe stupidly concerned. He should be inside. What I say, stay inside. This shit won't happen. It's seriously. But he's one of them people. He's got the hero complex.
So, are you guys? Do you guys mind? Is there a way up on the roof?
Yeah, there is, but you gotta go through the shop, and we really want no one else going through.
Okay, no, that's fair. I thought I'd ask and make for some cool footage. But we got militia members.
I'm going to point out up on the roof there is Dominic Black. And there's not any dispute about this from the defense, so I just want to clarify for the jury. I'll do it on the screen here if I can. This individual here, which is the one with the lighter shirt on, is Dominic Black. No dispute on that? Okay. So that is Dominic Black up there on the roof. Thank you. Keep going, please.
All this for property. What's the point? It's not your property. I can see if it was your store. Like, I understand it's your community. I get that, man, but your community should have
Now,
insurance.
can we please...
He's a fast runner.
Oh,
Run down.
yeah, don't instigate. Don't just stand there. They're not gonna cause any problems.
There they come.
Green Nation.
That's bullshit.
Yeah.
No, that's not cool.
Yeah.
But I think a lot of them just are scared.
It's the same as the earlier objection. If he wants to play my client, that's fine, but this is editorialing.
I understand the objection. The problem is there are portions of this that don't have anything to do with the defendant that describe the scene, and I'm trying to give the jury
That's
a sense of the
hearsay.
scene.
It's hearsay.
I'm not introducing anyone's statements for the truth of the matter asserted. I'm introducing it for the state of mind of the defendant as he watches
If
the
it's
scene.
not for the truth of the matter asserted, it's irrelevant.
No, it goes to state of mind, Your Honor.
State
I mean,
of
I don't know
mind,
why. This is why I feel like two of these men. One, the judge, he's okay, but I feel like he wants his time to shine. But if he's saying that anything the other man says is hearsay, why does the prosecutor continue to try to slip things in? But on the other hand, the judge isn't saying anything about it until the other lawyer objects to it, which leads me to believe that the judge is just kind of like, oh, defense says that? Okay, yeah, no, it's hearsay. It might be hearsay, right? But the judge isn't just picking up on it. Every time he calls the objection, the judge is like, oh, yeah, that's hearsay. Hearsay, no, you shouldn't do that. This is why it's hearsay. And then he goes into this big old rant for the jury to make himself seem more credible. You know what I'm saying? I don't know. Like I'm saying, it could be it could be hearsay. It kind of seems like it is, according to the way he explained it, right? It's not admissible unless he's under oath, and it has to be cross-examined, all that stuff, and the person isn't here in the room to be cross-examined or under oath. Okay, cool. But why didn't you call that out for the 2 minutes or so that we were watching someone else speak? You know what I mean? But the defense called it, oh, yeah, you're right. Hearsay. Judge is fishy. Either fishy or just not on it. I don't know.
Of the defendant. When he sees...
Someone else's... would you do me a favor and step into the library for a minute?
Did he just send the jury away? No all rise for the jury? What is going on? Oh, he's pissed. He didn't even... Could you step into the library for me?
Sidebars, and we've used them for a number of purposes in this case, which I think everyone would agree have not touched anything which is an essential part of the case, and mainly have been management issues. But the Court of Appeals rightly wants to have a full record made, which cannot be made when we're having a little sidebar. So, and when you state your objections, then I've stated you have to state the objection here, or else I'll have to excuse the jury. And I think we're going to get into this a little more deeply now. So I think we did the right thing to do that. and we'll try to keep it so that they're not inconvenienced too much just being in the library here. No, let me just set the stage here. I've talked about inaccurate things out on the media, and one of the things that I've read over and over and over again is about how I messed up the State against Jensen case, which is now pending downstairs. Actually, I had it 100% correct in the first place.
Wait, now he's talking about another case. Oh, he's just salty. They call him a fuck up before. So now he's just trying to be extra careful, and bro, guess what? You're messing up again because what is going on? I think my boy needs to step down or something, because if you're just following what the defense says and now you have to let the jury step out so you could explain this, like now you're talking about a whole different case.
I ruled that the disputed matter was testimonial evidence that had to be confronted, and your office appealed. This is 20 years ago, and it was fine. It was a big issue. It was a big case, and the state Supreme Court reversed and said, no, we're going to adopt a new rule that is to be applied in this case about waiver and forfeiture. And so it came back, and I said right in the record, this is going to get reversed again because it was an unsound ruling, unanimous. I hate to say that about the Supreme Court, but it's true. And of course, that has proved positive.
Okay, I get why he was talking about the other case. So he doesn't want it to go to the Court of Appeals like incomplete. He's making the case seem like a joke.
I tried the case according to the way the Supreme Court told me to try it, and that was 20 years ago. The man is still in prison, and the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues. I can't let you present evidence into this record, which is barred by the confrontation rule, and you're asking me to let this just run while this man is making descriptive materials to prove the state of mind of the accused. That doesn't make any sense to me at all.
First of all, Your Honor, nothing that's being said in this video can be construed as testimonial.
There was historical information that he was saying in the part that we did here.
Yeah, I mean, it can be misconstrued as testimony, but what I'm saying is why can't they just make him come in and testify on that? But anyway, that's just a little sneak peek of the judge. I mean, he's definitely got some PTSD from that other case, and he's saying basically he's got to do it by the rule to the exact point so that it doesn't mess up in the case of a court of appeal and blah de blah. My only problem is, again, is that he only calls things out when the defense calls something out. There's no personal, so far, there's no personal identification of hearsay as he says it. He's just letting the video run in front of the jury. Then the defense objects again, and he's like, oh, yeah, you're right. I don't know. But anyways, this is the start. This is the very start of the Kyle Rittenhouse case. It is a very interesting one. So if you guys want to see more of this, let me know for sure. Until then, guys, stay inside. Stay very safe out there. I love y'all. See you later.